Hi, I'm Janice Switlo, and today I'm going to discuss just how important it is to refer to yourselves, and I'm addressing Indigenous nationals now, to refer to yourselves clearly by your own name. As opposed to, when I'm speaking on issues, originally I used to speak about Aboriginal nations, but that term carries certain domestic legal definitions. I then moved on to Indigenous nations and nationals to, speak generically, but without intending to group into some generic form, but just really as a matter of convenience. But clearly I respect the individual nations by their actual names as I am informed by their nationals in their name from their language. So why is this so important? It's because of all the traps that the definitions are set out for you. And in specific, I'm going to talk about Section 91, Sub 24 of the Constitution Act 1867, formerly known as the British North American Act, and also Section 35 of the Constitution Act 1982. Now, everyone's very familiar, usually is Section 9124, that the arm of government that's responsible in relation to, quote, Indians and lands reserved for Indians, end of quote, is the federal arm. Now, recently, and of course, just to follow up, Section 35 of the Constitution Act, the existing, Sub 1, the existing Aboriginal and treaty rights of the Aboriginal peoples of Canada are hereby recognized and affirmed. So, and then of course you've got Indian Act, right? So if you confine yourselves within those terms which carry domestic legal definitions, then you're going to find yourselves in trouble later on. So let me explain. Now, there was a case in Supreme Court of Canada case in 2016, Daniels versus Canada, and I haven't had time to look into this, but these cases used to be referred to and cited as, for instance, Daniels versus V period R, Regina, the Crown. But now the reporting of the cases are using Canada instead of Regina, instead of the Crown, which I find interesting, and I hadn't, quite frankly, noticed before. So I don't know how long this has been going on. Anyhow, that's an aside for another time. So the Daniels decision. This is where the Constitution Act 1867 is amended. How? Through redefining, quote, Indian. And it says it determined that Indian, Inuit, and Métis peoples are Aboriginal peoples for purposes of the Constitution. Now remember, if you look to your treaties, look at how you're referred to in there, and that's an important starting point for making it clear that you haven't transformed into something else, that you haven't abandoned nationhood, that you haven't somehow come under these domestic definitions, and that you are, quite frankly, not in the Constitution of Canada. Canada's Constitution is based upon the permissions that your nations provided to the Crown through treaty. And the treaties were not ones where you gave up your sovereignty. You still hold that, as long of course as you're still a nation, and as a nation your treaties still exist. If you fall as a nation, if you abandon your nationhood, if you allow enough evidence to accumulate whereby it could be said that you at some point became merely a domestic ethnic minority, or some lawyer went into court and said that's exactly what you are by pursuing a Section 35 case. All of these things, you need to be careful that you do not fall for the traps. So, as I said, let me explain the Supreme Court of Canada, being an arm of government, knows full well what's going on and how and the part they play. Remember, I have at length described how the court amended the Constitution Act 1982, Section 35, by adding in and writing in a section that does not exist there, namely a Section 1 charter equivalent. Remember, Section 35 is outside of the charter. Why? Because Indigenous governments are not part of Canada. They're not part of Canadian governments. And so this is why in all of these agreements that are signed off for land claims and self-government, it has, it requires the Indigenous party to accept applications specifically of the charter. That's actually one of your key things that shows you're not exercising your own jurisdiction. You're actually coming under Canada and exercising some form of delegated or newly created jurisdiction that will be contained in, oftentimes unseen and unknown as to what form they'll take, pieces of legislation that will be passed in the future. So, as I said, I wanted to reference two sections of the Daniels case. That is, first, paragraph 37. And this is where the court is saying, you know, here's what's really going on. The constitutional changes, the apologies for historic wrongs, a growing appreciation that Aboriginal and non-Aboriginal people are partners in Confederation, the report of the Royal Commission on Aboriginal Peoples, and the final report of the Truth and Reconciliation Commission of Canada all indicate that reconciliation with all of Canada's Aboriginal peoples is Parliament's goal. Now, this is not the goal of Indigenous nationals, to my knowledge. And look at the possessory language, Canada's Aboriginal peoples. Clearly a domestic element, and this is Parliament's goal. And the court is using this to say, this is why we're going to expand and give a definition to Indian under the Constitution Act 1867 so that it fits with this, this goal. And it's rare that you see that, you know, specifically set out. Now, the other, so, and again, all of those things that the Supreme Court of Canada references here, you know, remember that Indigenous nationals and nations did not appoint people to the Truth and Reconciliation Commission, to the Royal Commission on the Aboriginal Peoples. These are all, you know, these are not independent, I guess what I'm trying to say, they're not independent, truly independent reviews of the problems, the issues, the foundations, and how to properly proceed. They are all elements of implementing, quote unquote, Parliament's goal, end of quote. That goal has not changed since Confederation. Now, this, you know, commenting a growing appreciation that Aboriginal and non-Aboriginal people are partners in Confederation. No, you know, you are not. Métis, yeah, I mean, they've always been part of Canada. But Indigenous nationals, Indigenous nations, no, you were always considered foreign nationals. Canada, remember, had to deem you citizens. Métis were involved in elections way early on. Indigenous nationals were not able to vote until 1960 when, as I said, they were actually deemed citizens of Canada, because they clearly were not. Why? Because they were clearly of another nation, nation-to-nation treaties. All that basic evidence is there. But the Supreme Court of Canada, using, if you will, the Métis lawsuit, takes this opportunity to set out, well, this is really what Parliament's goal is. But I put it to Indigenous nationals, what's your goal? And of course, what are you doing then to achieve that goal? And that's where I like to help. So moving further, one other paragraph I wanted to point out, and I hope you'll be able to follow me with this. The Crown, it's a section, paragraph 44. The Crown, however, submits that including Métis as quote-unquote Indians under Section 9124 is contrary to this court's decision, the Supreme Court of Canada, in R versus Blais, 2003 to SCR 236. With respect, this court says in Daniels, I think Blais can be easily distinguished. The issue in Blais was whether a provision of Manitoba's Natural Resource Transfer Agreement, which allowed Indians to hunt out of season, included Métis. It is true that the court concluded that Indians in the Natural Resource Transfer Agreement did not include Métis. But what was at issue was a constitutional agreement, not the Constitution. This, as the court has noted in a case, is a completely different interpretive exercise. Well, what's the distinction? Why was that necessary? Well, there are no treaties with Métis. There cannot be any treaties with Métis because treaties are limited to nation. Métis coming under Canada. So when we're talking about the Natural Resources Transfer Agreement, it was critical for the government, including the courts as the arm of government, to be consistent with the treaties. So it had to distinguish, and currently is spelling that out. This is what we have, you can distinguish this. It's a different thing that we were looking at because, so sometimes Indians will include Métis and sometimes it will not. Here it's saying that, well, what was at issue was really a jurisdictional void as to who is responsible for Métis. I don't have an issue about deciding which arm of Canadian government is responsible for Métis. They're considered, court says they're clearly distinct peoples, but they're also clearly Canadians. They're clearly Aboriginal peoples of Canada, as contained in Section 35. I, again, don't have an issue with that. What I do have an issue with, though, is watering down what Indigenous nationals are, what the Indians are. If you look at the terminology used at the time of treaties and what Indian means, again, there were no treaties with Métis, nor could there be. There can be land claims agreements. I think they settled one recently. But it's impossible for the court to go the distance and say that, Indians, until such time as the treaties fall. So, and hopefully I haven't lost you on this. My point is, while Canada is busy trying to create this homogeneous thing of Aboriginal peoples of Canada, Canada's Aboriginal, how did the court put it? Canada's Aboriginal people. Possessory, ours, okay? And in order to be more attractive, Canada just substituted the word Indigenous for Aboriginal because, it just looks better. But if you look at the courts are clear. We're talking about Aboriginal law. They can't change that concept. It's Aboriginal law because Indigenous law, which I speak a lot about, it could be seen as the court accepting that there is another type of law, basically the law of the land that exists. These courts are confined to domestic law, the law of Canada, vis-a-vis Canada, its constitution, its governance, all limited by and defined by the permissions granted by the Indigenous nations by treaty. So while it's hard to, for me to list out all the nations, for instance, and so I will use Indigenous National and Indigenous Nation, it's imperative that the nations themselves name their nation. And their nationals say, I'm, an Anishinaabe national. And something I'm, to look into, right? You can't incorporate a company using someone's name when they are not that name. So with all of these incorporation, and again, it'll take me some time to research this further, but I just put it out there for people to think about. That, because I think someone's asked me a question about this a while back too, that, they're using our name and we want to tell them to stop. Well, it also may not be lawful for them to have registered that name in the first place. It can be an obligation, for instance, of the Ontario's Corporation Act to deny the name. Now, the issue doesn't come up until the person who holds the name actually makes the complaint. So I'll, stay tuned, and I'll see if I can get some information together and put an episode together on that. So it's true. Even more so, use your name. Those who have the right to use your name. Incorporated entities do not have the right to set up, for instance, the ANGA, the Anishinaabe Nation Governance Agreement. They do not have the right to set up a legal entity incorporated under provincial or federal law that uses the name of an existing person or nation. Generally, the law applies in terms of individual names. So someone could not go ahead and incorporate an entity in Ontario or BC called Janice Switlo Inc. I could, because I carry the name, but others could not. So that helps you understand a bit about the law. But when it comes to nations, entities, there's a lot more I need to look at before I can give you further comments on that. And that's all I have to say for now.